Hello, my name is Adrian Johnson and I serve as your district judge here in Lowndes County. I want to share with you some of the consequences that driving under the influence of drugs and alcohol can have on your life. Let's imagine a typical Friday night in Lowndes County. There may have been a football game. A young person may be out celebrating with some friends after the game. Let's imagine our young person is 17 years old. They're a senior in high school. They've gone out after a football game and had a couple of beers with their friends. On the way home, they see blue lights in the rearview mirror, and they're being stopped by an Alabama state trooper. The stop could be for something as simple as failing to signal, failing to yield, failing to stop at a stop sign. Something otherwise innocuous could cause significant problems in their life from that point forward. So as soon as the trooper approaches the vehicle, they may notice the odor of alcohol because the person has been having a few beers or some other alcoholic beverage, or it may not even be alcohol. Under Alabama law, you could be charged with driving under the influence for using marijuana, even for potentially using prescription medication. Any substance that could alter your ability to operate a motor vehicle can cause you to be charged with driving under the influence under Alabama law. So the officer may notice the odor of alcohol or the odor of marijuana, and that officer will then initiate a field sobriety test. So upon asking that young person to step out of the vehicle, they'll ask them to do a number of different things to determine whether or not that officer believes that person is incapable of operating a motor vehicle. Now you need to be aware, under Alabama law, if you are under the age of 21, the blood alcohol content in your body must be less than 0.02 blood alcohol content. If you are over the age of 21 years old, then your blood alcohol content must be under 0.08. Now that's a significant distinction because in a typical young person, depending on their body size, male or female, 0.02 blood alcohol content could equate to as little as one alcoholic beverage that could cause you to be impaired enough to receive a driving under the influence charge. So our young person, could be a male, could be a female, having done that field sobriety test, having done the walk and turn, having done what's called the horizontal gaze nystagmus test, having done their ABCs, the one-leg stand, all of these different tests that our Alabama state troopers are trained to detect impairment, that trooper will make a decision about whether or not to place that person under arrest and charge them with driving under the influence. Let me assure you of this. If you are charged with driving under the influence in the state of Alabama, you will be arrested. Because of the age of our person in this hypothetical situation, being 17 years old, they are ineligible to be admitted in the Lowndes County Jail because minors in the state of Alabama cannot be admitted to a county jail except under very narrow circumstances. We do not have a juvenile detention facility in Lowndes County. We contract with the Dallas County Youth Detention Facility in Selma. And so the Alabama State Trooper would then have to communicate with our juvenile probation officer, Ms. Keisha Lee, who you will hear from during this video. She will authorize that person's admission to the Dallas County Youth Detention Facility. Alabama law requires that any person charged with driving under the influence must be held in either a youth detention facility or a county jail until that person's blood alcohol content drops below the legal limit, which is usually a minimum of 24 hours. So, now that that young person has been stopped, has been placed under arrest by an Alabama state trooper, or it could be municipal law enforcement, or it could be a sheriff's deputy. But that person's been placed under arrest, they've been charged with driving under the influence. So then, that person will have to come before me, as the judge in the county, for me to set a bond. Now this person has not been convicted of anything yet. They've only been charged. However, a bond has to be issued, and ordinarily we will allow that person to make a bond, then they can be released from jail. Their charge is still pending. So then a court date will be set. And that's when the difficulties can only increase. Because at that point, now that they've only spent 24 hours in jail, they are subject to spending significantly more time in jail upon a conviction and incurring significant financial expenses. So ordinarily, we would appoint a lawyer to represent the minor or an adult, if it's an adult charged with driving under the influence. And as I stated earlier, it could be a charge of either alcohol, marijuana, any other illegal substance under Alabama law, a combination of all these things, or even prescription medication. Because certain prescription medication can impair a person's ability to operate a motor vehicle sufficient to merit a charge of driving under the influence. So now our young person has been arrested, they've been charged, they've been admitted to the youth detention facility, they're out of the youth detention facility now on a bond. They've met with their lawyer, and their lawyers advised them of what their options might be. So now we come to the time when the matter will come before the court on the trial date. At that point, the state of Alabama, represented by the local prosecutor, will offer evidence to the court to determine whether or not that person is guilty beyond reasonable doubt. Now, the burden of proof is upon the state of Alabama to convince the court of that person's guilt beyond a reasonable doubt. However, based on the hypothetical that we've mentioned, that state trooper or that law enforcement officer will be in court to testify. That officer will testify based on the basis for the stop, based on his or her observations of that young person, why they believe that person was operating the motor vehicle under the influence of some substance, either alcohol or drugs. Then they will testify about the various steps that they took in making a determination. And we've left out one factor. There's something that you will have to blow into to determine whether there is blood alcohol content. That machine is presently at the Lowndes County Jail. And so even if a young person has to be transported to the Dallas County Youth Detention Facility, they will be making a stop by the Lowndes County Jail to utilize that machine. You'll have to blow into that machine to make sure that you don't register any alcohol in your system. If the alcohol is registered, it will print out, and that piece of paper is admissible in a court of law to determine the blood alcohol content of that individual at the time or shortly thereafter, after the time of arrest. So all of these factors will be considered by the court in determining whether that young person is guilty of the charge of driving under the influence. As I stated earlier, that's when the difficulty can start. Because under Alabama law, driving under the influence is a very serious offense, and it can carry lifelong consequences. Driving under the influence, a first offense, the court can impose a fine, a mandatory fine, of between $600 and $2,100. That person could be imprisoned in the Lowndes County Jail or the Alabama Department of Youth Services for up to 1 year. That person will lose their driver's license for a minimum of 90 days. That young person could also be subject to a provision called ignition interlock, which means that they will have to have a device placed on their vehicle, make sure that they don't register any alcohol in their system every time they operate that motor vehicle from that day forward for a significant period of time. That could be 6 months, could be a year, or could be longer. There's an installation fee as well as a monthly maintenance fee. If that person is convicted, not only will they have to pay the cost and fines, lose their driver's license, potentially serve more jail time, they'll also have to complete a substance abuse treatment program mandated by Alabama law through our court referral program. As a juvenile, that person would be placed under the supervision of the Chief Juvenile Probation Officer in Lowndes County, Ms. Keisha Lee. And so there could be additional requirements to be on supervised probation that could include a curfew, that could include community service hours, random drug and alcohol testing. The violation of any of those may result in an additional incarceration in the youth detention facility. And so all of these factors coming into play could have a serious impact on your life. Our young person in our scenario here would now have a conviction for driving under the influence on their record. That driving under the influence conviction, even as a juvenile, could impact their sentencing going forward as an adult. Let's say our person is convicted of a DUI at age 17. Then when they turn 21, they go off to college and pick up another DUI. Under Alabama law, any DUI within the previous 5 years can be utilized for sentencing purposes on a second or subsequent DUI. And the law recently changed a few years ago that juvenile convictions can be utilized for the purposes of sentencing either as a juvenile or as an adult. And so now our DUI that we received at 17 could impact us as an adult. And the enhancements only increase with additional juvenile or additional driving under the influence charges. A second offense would be a fine of between $1,100 and $2,100. It could result in significantly more time in jail. It could result in a longer driver's license suspension, a longer period of time that person might have to use the ignition interlock, and those only go up from there. For a third DUI, you're subject to a fine of between $2,100 and $10,000, imprisonment in the county jail for up to a year with a minimum period of time to be served of 60 days. Completion of the court referral program, lose your license for up to 3 years, and you may have to do ignition interlock. Any fourth or subsequent DUI under Alabama law can be prosecuted as a felony, which means you are subject to be going to the Alabama Department of Corrections if you're convicted of a charge of driving under the influence as a felony. And so the penalties are severe because the charge is severe. These are not things to be taken lightly. And so when one of your friends suggests, hey, let's go drink a beer, or hey, let's have a drink, or hey, let's smoke a joint, that one beer, that one drink, that one joint, that one pill could impact your life from that point forward in a very negative way. So it's just not worth the consequences. It's not worth the financial difficulty, the potential loss of your liberty and being in jail. It's not worth the price of it impacting your life from that point forward. So I would encourage you to think about our discussion here today and the consequences that you may suffer should you find yourself in that situation, and do everything within your power to avoid that at all costs.
My name is Carolyn Marie Tyus. I'm the mother of 4, second oldest child, Renata Tyus, who was 21 years old at the time. He was a student in college. He was a child that he says the party doesn't start without him. Food was his thing, so I could be cooking dinner, and the next thing I know, the doorbell is ringing, whether it's my house or my mom's house. And the kids will be coming over and they'll say, Renata invited us over. He sent us a copy of the menu. He said, this is what's on the menu today. He was just that kid, anything that say dress up day, he was involved. Crazy sock day, switcheroo day, it doesn't matter. He was involved. He was just that fun, loving kid that you want to be around. Honor roll student. He wanted to be a surgeon. His sister, Jada, she was graduating from the 6th grade, and he was coming home. It was on a Thursday, so he came home that Wednesday, and we got to hang out and laugh and cut up and with her, and Thursday was graduation. Friday, me and her was traveling to Orlando. He took us to the bus, as a matter of fact. And so he reminded me, Mom, my car need a water pump. I need groceries. I need money for school. So I was like, okay, son. So I won't get back till very early Monday morning. So why don't we just do lunch? We just have a family lunch. All 5 of us just have a family lunch. We'll talk about what you need when we get back. And he was like, okay, that's great. Once we got there and got situated, I was in the room with a lady that I knew, but I didn't really know her. So I silenced my phone. As I was laying down, one of the ladies come out. Matter of fact, Miss Sism, she was over the trip. She came to my room and she says, hey, Miss Tyus, I need you to call home because I've gotten a call that you need to return some calls. So I look at my phone. I realize I've missed so many calls. And it was like over 20-some calls that I had missed. Who's going to be able to tell me what I want to know? And that was my sister. So I end up calling her back. And she tells me, where are you? You need to be coming home. And I was like, I can't come home. You know, me and Jada just got here. This is her 6th grade graduation trip. She says Renata had an accident. So I'm like, that's fine. He has insurance. He'll get it taken care of. But in the bottom of my stomach, I felt like there was something still wrong. Something didn't feel right. Well, she wasn't giving me any information, so I'm kind of like having to drag it out of her. In order for me to find out what was going on, I asked her, could I speak with him? And that's when she told me he was gone. So I'm saying, okay, did he just up and walk out? Is he in the bathroom? You know, what gone did she mean that he was gone? But at the same time, I could still feel something in the bottom of my stomach that I understood what she said. Once I realized that what she meant that he was gone, I lost it as a mom, because I'm sitting here saying, I'm not supposed to bury him. He's supposed to bury me. I just wanted to get home to touch him. It seemed like it was the longest ride ever. The young man that crashed into my son, he was his mid to late 20s. Him and his sister had went to a baseball game over at the Biscuit Stadium. They left the stadium, went over to a brew pub across the street. He was ready to go. His sister wasn't ready to go because she dated the bartender at the brew pub. So she gave him his keys, which at the time already had 4 DUIs. He had already crashed into someone, his 4th DUI. He had no driver's license, no insurance, no nothing. And she entrusted him with her keys. He left the brew pub, went around the street to another bar, had a couple of drinks there. He checked out, or he cashed out at 1:56 a.m. He crashed into my son at 2:01. He was doing 67 and a 25. They both were rushed to the Jackson Hospital, where my son was pronounced dead. This young man walks out with his family with not even a scratch on. And my son, unfortunately, comes out in a body bag to be put into a hearse to be taken away. He was charged with vehicular homicide. He pled to manslaughter, which he's doing 20 years. Going into a funeral home to pick out a casket, to pick out a suit, to pick out what are we supposed to do at a funeral, when I could have been going to the grocery store or giving him that money for his books, or just giving him money, period, just doing other things. The choice that he made was to drink and drive, and crash into my son. One of my friends, he's a police officer, and he works the crime scene, and he was the one that delivered me the bag. When he came, he didn't want to give me the bag, but he was like, this was the only thing that was left of him because of the glass, and all of his clothes were bloody and stuff, so I couldn't get those or shoes or anything back. Me getting that bag back, and I didn't get the bag back immediately. It was like a few weeks after he passed away when I received the bag. But just to get that back, it took a lot out of me, because that was something that was his. But it's something that I can carry with me every day. I can look at, because it was a part of him. I just want people to understand that everybody can be a leader, make better choices. And before you take that sip, you should already have a plan, because it is 100% preventable. I don't want anybody else to have to bury their child or their family member, as I did.
Hi, my name is Keisha Lee. I'm the Chief Juvenile Probation Officer for Lowndes County Juvenile Court. I am also the chairperson for the Lowndes County Black Belt Coalition for Underage Drinking. Today I would like to talk to you about driving under the influence. The first time offense for a juvenile that drives under the influence may be that the child will be placed on a consent decree. A consent decree is terms and agreements that are drafted by the juvenile court for a minimum of 6 months. During the 6 months, various things may be imposed on the child, such as drug and alcohol treatment, counseling, and random alcohol and drug testing. Once the child successfully completes the term of that agreement, that child, as well as the charge, may be dismissed from juvenile court. On the second offense of driving under the influence, the child may be placed into detention. However, we cannot place a child into detention for driving under the influence unless we have a clearance from a medical physician. Once that child is placed into detention, that child will have a right to a 72-hour detention hearing. During that detention hearing, the judge will determine probable cause, whether to detain that child, continue to detain that child, or to release that child. If the child is released, that child will be placed under conditional release, meaning there will be terms that the child would have to follow before coming to court, prior to coming to court. If the child returns to detention, that child will be placed into detention until further notice from the juvenile court or until the trial date comes. Once the child comes to court, at that point, the child will either plea or ask for a trial. If the child asks for a plea or if the child asks for a trial, once the child is adjudicated delinquent, that child may receive probation, a minimum of 6 months. During that 6-month probation, the child will have to abide by all laws, codes, rules, and regulations set by the juvenile court. If the child breaches that probation within that 6-month period, a revocation of probation can be filed by the juvenile probation officer. If that violation is filed, the child will be either sanctioned by going to detention or adding additional terms to that probation for that child to complete. Another option of a sanction that may be imposed is the child going to the Department of Youth Services. If a child goes to the Department of Youth Services for breaching the terms of probation, that child will be placed there until he or she successfully completes that program at the Department of Youth Services. Upon completion of the Department of Youth Services, the child will be placed on aftercare, which is a period of 6 months. Aftercare occurs when juveniles are discharged from Department of Youth Services. With aftercare, services are designed to prepare juvenile offenders to enter back into the community. The overall goal of reentry programs is to reduce recidivism rates of juvenile offenders.
LCBBC's focus is to make Lowndes County a safe community for all our children by providing them with the knowledge and understanding in hopes that it may prevent incidents in the future related to underage drinking. Judge Adrian Johnson discussed a hypothetical case that began on a Friday night after a football game in Lowndes County, Alabama. He profiled the processes of his court and what the consequences are for driving while under the influence. Carolyn Tyus, Mothers Against Drunk Driving, Alabama volunteer, shared her personal account of the impact that a drunk driver had on her family. And lastly, Chief Juvenile Probation Officer Keisha Lee discussed what a consent decree and probation entails. She also discussed all of the responsibilities of juveniles placed under her supervision while driving while under the influence. We do hope that you have been enlightened about the legal consequences of underage drinking and driving while under the influence.